With all the FTX media attention, the most significant crypto story of the year may be a little under the radar. The SEC and Ripple are currently in the throes of an intense legal battle that may set a legal precedent for the entire industry. My guest today, Aaron Kaplan, will help clarify some details on this vitally important lawsuit. Aaron, welcome to the Daily Drop.
Hi, Bobby. Thank you for having me.
Well, look, I'm glad we have you because I know that you're really going to explain what is pretty complicated for our audience, but is really important. So let's start at the beginning. Why is the SEC suing Ripple?
Well, the SEC brought a suit against Ripple at the end of 2020, alleging that it sold XRP, its token, as an unregistered security. The SEC's complaint alleges that the defendant, meaning Ripple here, failed to register their offers and sales of XRP or satisfy any exemption from registration and were therefore in violation of the registration provisions of the federal securities laws. The legal theory here is that XRP is an investment contract and therefore a security. Under the federal securities laws, Ripple would have needed to register XRP before conducting a public sale or qualified for an exemption from registration in order to legally sell its digital asset, XRP, in the United States. In essence, this is a significant moment for the crypto industry as it marks the first time a determination is being made whether a top 10 market cap token is a security. And the outcome of this matter arguably impacts almost every token in the crypto market except for Bitcoin. SEC Chairman Gensler has noted multiple times that many digital assets are securities, and the determination whether XRP is an investment contract and therefore security really represents the most dispositive determination of whether that statement is correct.
Okay, let me ask you. Let me just jump in for a sec, just to clarify some of these details, right? So the SEC this isn't like the first cryptocurrency that the SEC has sued. I mean, they've gone after a few of them. Why is this one? It's almost being viewed as like the landmark lawsuit for crypto. Is that accurate?
I would argue that the library case that happened, that came out, the summary judgment the past few weeks, is just as important, as a lot of the facts are very similar. I think that one of the reasons that people are very focused on the XRP component here and whether that's an unregistered security is specifically because it is one of the larger cryptocurrencies. And also, I think it's the last line of defense for people who are saying that tokens aren't securities. If the Ripple matter comes out such that it's a determination that it's an unregistered security, that's an investment contract, and therefore it is a security, I don't think anyone will be able to make that argument anymore. And right now, anyone who's making that argument is best served by Ripple not being a security.
Okay, let me ask a question about the profile, because I think that was quite brilliant what you said, right? Because you're right, like it was really like last week or the week before, the SEC had sued Library and they won very similar case. But the Ripple one is getting way more attention. And is it just that? Like, is the SEC targeting, I don't know, for lack of a better term, the more famous cryptocurrencies to send a message?
I don't think it's that at all. Ripple raised, I believe the SEC said $1.3 billion. Library now raised, I think they raised a couple million at most. So the magnitude of the result is bigger. But the precedent and the case law already exists. And before that, there was Kick and Ton and other matters. And you could argue that the SEC is undefeated when it comes to the determination of whether a token is a security.
Okay, well, let me ask you a question then. So if that's the case, and I can tell you're a lawyer, you argue so persuasively. Why don't they just sue every single one?
I don't think it's hard for me to speak on behalf of the SEC, but I don't think that they're trying to crush the industry. I think that they've really allowed, as much as they could, innovation to continue. And when the industry reaches a certain size, there needed to be regulation in order to ensure investors are protected. What we've seen recently, particularly with the FTX saga, is that the retail investors left holding the bag. And when that occurs, the best way to prevent that from occurring in the future is the application of the federal securities laws.
Right. It is interesting that they are sort of picking and choosing. And I know Gensler has gone on record saying he believes all 20,000 non-Bitcoin cryptos are securities. So I guess it's a little bit unclear to me who they choose to sue and why, because they could almost pick anyone.
Again, it's not a question of if, it's a question of when enforcement happens. Violation of the securities laws occurred in theory. And if that violation has occurred, it's the SEC's responsibility to enforce the laws and make sure that those preventions don't occur. Those violations don't occur in the future.
Okay, let's get more into it after the break. We got Aaron Kaplan here on the Daily Drop. Welcome back to the Daily Drop. Okay, let's talk implications. So let's say, since the SEC is apparently undefeated, let's say they win again. What are the implications of this outcome for the broader crypto community?
This case really has far-reaching implications for the entire crypto industry. At its core, the case is about the definition of a digital asset and whether cryptocurrencies meet the U.S. government's definition of a security. There are countless companies operating in the crypto space today, many like Ripple, who raised capital by issuing coins and tokens. And if the courts rule in favor of the SEC, virtually all these companies will be involved, in theory, in unregistered securities transactions and offerings, and could be in danger of enforcement action from the SEC. If this were to happen, a host of companies would likely have to adjust their practices and platforms to really to fall in line with securities regulation or face stiff consequences.
Okay, so I guess, and you brought up a point that I didn't quite understand before, which is really interesting, right? So, because you're right, the library case has already set a legal precedent, but the Ripple case feels bigger. So, like, do you think that the Ripple case is really the precedent, or they already have it? Like, how high are the stakes regarding this Ripple outcome?
I think you could view it both ways. On the one hand, the SEC, as I mentioned, has an unbeaten record against crypto industry and specifically token issuers, Telegram, Kick, Library, etc. And a determination that XRP is an investment contract is really just another win from that standpoint. On the other hand, the crypto industry arguably views the Ripple case as the last possible defense of the argument that tokens aren't securities. So the outcome of the case either way will have a major impact on the psyche of the crypto industry and how the major players view themselves in the context of regulation under the federal securities laws.
Let's talk a little bit about the Howey test, because the way I understand it, the SEC is discerning whether or not a cryptocurrency is a security based on 1940s legislation regarding oranges, which seems a little bit different from cryptocurrency. So why are they using the Howey test?
The beautiful thing about the Howey test is that even though it applies to oranges, it's so tried and tested that it really doesn't matter what the specific underlying asset is. The Howey test is used to determine really whether, as I mentioned, an investment contract exists and therefore security. Now, as you mentioned, it was established by U.S. Supreme Court decision in 1940, and I don't really anticipate the Howey test will be replaced anytime soon. What we've seen is that the existing federal securities laws, the legal precedents, and the regulatory frameworks the SEC has provided, including for the trading and custody of digital asset securities, are really already more than sufficient to properly regulate the crypto industry.
So, okay, look, I'm not a lawyer, although my dad's a lawyer. I don't know if that gives me like a junior lawyer status. But okay, so look, the way I understand the Howey test, it's four basic statements, really, right? It's an investment of money derived from the efforts of others for the purposes of investment, right? For profit. And then it's like a common enterprise, right? This is the language, but it occurs to me, and again, I'm just a layman, that almost anything is going to fail that test, right? It's so broad that of course all the cryptocurrencies are going to fail that test. It seems like it's set up to do that.
Well, I would argue they don't fail it. They meet the qualification of an investment contract under the Howey test. Now, the Howey test specifically says when there's an investment in money in a common enterprise with the expectation of profit derived from the efforts of others, there's an investment contract and therefore there's a security. Put simply, if a person invests money with the goal of a profit, it is very often a security. And the issuer of that security must therefore abide by the federal securities laws when offering that security for sale. Companies like Ripple sold billions of dollars worth of tokens to investors with the goal of using the money raised to build out a network or blockchain. The investors in those tokens invested because they were seeking a profit, and that profit would be derived from the efforts of the engineers, the foundations, the insiders who were responsible for bringing those projects to fruition and generating a return for those token investors. So essentially, Really, the only people who are arguing that XRP is not a security, who actually could say that with a straight face, are really those best served by XRP not being a security. But they are really doing so at the expense of their customers and the investment public, because going forward for the industry, the way to end the crypto winter, the way to basically move forward, is the clear application of federal securities laws. And I think the Ripple decision will mark a major step in that direction.
I mean, you're such a brain. But look, the only thing I'll say, we're going to go to break. In my view, a lemonade stand also meets all of those criteria for the Howey test. I don't know if the SEC is suing any lemonade stands anytime soon. I got Aaron Kaplan here on the Daily Drop. Welcome back to the Daily Drop. Okay, well, since like this whole conflict seems to be hinged on defining what a security is, as per the Howey test, do you think that the definition needs to be revised, or do you think it is fair? The Howey test is fair in determining this outcome?
I think it's the perfect test to use to determine whether an investment contract exists. Again, the concept of an investment contract is supposed to be broad. It's the catch-all sort of classification for securities. The courts historically, they don't look at whether it meets a certain form. They look at the economic realities of the transaction. They look at basically the substantive nature of the transaction. If you look at this, people invested in tokens in general with the goal of speculating from the efforts of others to achieve a profit. And it might not be the perfect test if you're arguing that crypto is not a security, but if you look at the real facts and circumstances, there's no way around it.
Oh, man, who's going to beat you in an argument? Nobody. But look, I will say it is interesting because I think it just feels a little bit forced, right? Because you essentially have two main regulators competing against each other, right? You have the CFTC and you have the SEC, and it seems like what that is doing is sort of like devolving into this argument where we're sort of trying to define the full complexity of cryptocurrencies into binary commodity or security labels. Is that fair?
I think that the overwhelming majority of digital assets, almost everything falls into one of those two categories. I would say Bitcoin is arguably a commodity, but every smart contract-based network token is very much likely a security. Now, stablecoins are sometimes it could be both in either one maybe, or something potentially a little different, but 99.999% of digital assets fall into the securities or commodities category, with the overwhelming majority, meaning everything virtually besides for Bitcoin, falling into the securities category.
Okay, let's take the conversation a slightly different direction. And again, like we're just speculating here. There is a bit of a conspiracy theory that, Gary Gensler went to school with Sam Bankman-Fried's parents and they are all in cahoots. Or, I don't know if that's true or if it's not, but it is interesting because at the core of that is this idea of, do you think that the SEC or other regulators have any sort of economic incentive to punish specific cryptocurrencies?
No, I don't think there's any kind of motivation for the SEC to selectively enforce the rules or to punish any cryptocurrencies. The commission has really succeeded in enforcing the law uniformly, and it doesn't matter on the size or the reputation of the token. The SEC's main goal is to protect retail investors, right? Particularly here after the FTX sort of saga, where everything really that's going to be left in its wake is basically retail investors being left holding the bag and losing almost the majority, if not all, of their money. And what basically will enable the industry to move forward and for there to be continued innovation is really the application of the federal securities laws. It's a clear and established framework. It's meant to protect investors. It's meant to make sure that markets are fair and orderly. And it's also meant to make sure that customers' funds and assets are properly segregated and protected. And obviously, many in the industry have chosen not to adhere to the SEC's and the federal securities law frameworks. And we've seen the negative consequences as a result of that to investors.
Well, look, it makes me feel better because I know you're very honest, which I appreciate. So you don't think there's anything nefarious going on with the SEC? Like they're just kind of being very hardline to protect consumers.
It's not even consumers here. Again, investing is arguably the most highly regulated industry. When you are taking people's hard-earned dollars and providing, in theory, an opportunity for them to, or a venue for them to generate a return through speculation, you should be regulated. Because in the event that retail investors are left holding the bag, you could have a Great Depression type issue. I mean, one of the reasons for the establishment of the federal securities laws in 1933 with the Securities Act in 1934, with the Exchange Act, was a direct result of the over-speculation by retail investors during the market boom of the 20s and then the crash in 29. And all of a sudden, you have lots of average people who have put up all their savings and weren't properly protected. So I think this becomes more of a consideration for how do we protect the investing public? How do we protect retail investors? What we saw in the industry is that they were advertising towards retail investors. Why were they using major celebrities in FTX commercials? Why? Because they wanted the average person to put their money in. But if they want that, it comes with the responsibility of having to make sure your customer funds are protected and to make sure that their assets are properly segregated. And that in theory, if they lose money, that's okay. But if their money's stolen or commingled or basically
You know what,
disappears.
Aaron, I have to say, that is a mic drop. We got you for one more segment. We got Aaron Kaplan here. Welcome back to the Daily Drop. At the break, I called Aaron the Eminem of lawyering. Now you know. All right. Okay. So, how do you think this turns out? Let's just start there, right? As we wrap up, is the SEC going to win again? You think?
I anticipate the SEC will win this case, as really every indication points to a decision in the commission's favor. Just in November, a very similar case came about, which we mentioned before, with Library in the United States District Court for the District of New Hampshire. And in that case, the court ruled that a blockchain-based file sharing network called Library violated securities laws by selling its tokens without registering with the SEC. The facts are very similar in this SEC Ripple case, so I expect a similar outcome from the Southern District of New York.
Okay, so let's assume the SEC wins, because they always seem to win. How many other people are they gonna sue? Like, I feel like they're making their point, and you said anecdotally, you know, in your view, 99.9% of all the cryptocurrencies are securities. I mean, at a certain point, you can't just sue everybody, can you?
So I think there has to be you have to separate the different elements of this. I don't necessarily think the SEC is going to go after every issuer, every token issuer. I do think that there'll be a lot more attention paid to intermediaries, the virtual currency exchanges, the custodians, because that's where we've seen these centralized points of failure. Obviously, that's what happened, at least abstractly, with FTX, and it's what happened with other institutions. So I think what's really necessary as a first step and a major step forward is for the industry, particularly the intermediaries, to come register under the federal securities laws. And Chairman Gensler has said that virtual currency exchanges should register under the securities laws, which would mean that they would either have to become ATSs or exchanges. And I think that's a major step forward. I think there'll be a little bit more leniency on the issuer side, because I don't think that it's the commission's goal to sort of to destroy the industry. I think what they're trying to do is make sure that investors are protected, and the best way to do that going forward is to make sure that intermediaries are properly licensed as broker-dealers.
So you referenced FTX, and obviously everybody's talking about FTX all the time, but do you think that the sort of aftermath of FTX is going to expedite anything the SEC is doing?
Yes, very much so. I think that what's clear from the FTX situation is that a lax or non-existent regulatory framework, either from jurisdiction shopping or choosing a wrong regulatory framework, led to excessive risk being taken and investors being harmed. And the best way forward to ensure that that doesn't occur again is to make sure that those intermediaries are properly licensed under the federal securities laws, which ensure the investor protections and also ensure the proper enforcement mechanisms to make sure that those institutions are following the rules they're supposed to be following in the first place.
Okay, Aaron. Luckily I'm not a lawyer, and I don't have to go against you because I know I would lose like every single time. But I'm going to give you 1 minute to wrap up. What can we take away from the SEC versus Ripple saga?
I would say that the stakes are tremendously high for the entire digital asset industry. Some in the space have been calling for regulatory clarity for years, but that's really mostly in an effort to avoid government oversight and sidestep really the regulatory requirements they are legally beholden to. And I'm hopeful that a decision in this case will end those calls for clarity and set the industry on a path towards greater legitimacy. As evidenced by the FTX saga, we need greater protection against fraud and greater ability to safeguard customer securities. And the Ripple decision, in my opinion, will create the groundwork of the application of the federal securities laws, the clear application, which will allow for investors to feel confident and to trust the industry and basically move forward from the crypto winter we're currently in.
Okay, serious question. Aaron, when the SEC sues my lemonade stand, will you represent me?
The question is, did you read the accounting book? You know, the lemonade accounting book?
Okay, cut. Look, Aaron, I appreciate you. We've all learned a lot, and I'm really happy you came to my show today.
Oh, thank you so much, Bobby. Honestly, it's so funny when you brought up the lemonade stand. I've read that book like 10 times. I'm like, I'm just not that good at accounting.
All right, we got to go, but Aaron, please come back. Appreciate you.
Appreciate it, man. Thank you.
While lawsuits don't make the sexiest headlines, their outcomes often disrupt industries more than high-profile scandals. As regulations become a larger part of the cryptocurrency ecosystem, the outcomes of these pivotal lawsuits will dictate the direction of the entire industry. For a nascent industry, these crucial battles could set the table for the next decade, for better or for worse. We'll see you next time on The Daily Drop.